day, Ashish Makhija sir. We just start in a moment. The participants are joining in the webinar. The administration department is allowing them to join the webinar. So just few moments.
That's okay.
And a warm welcome to all the participants present here for the day 3 of the 5-day virtual course for the IBC exam preparations. Today, we will be discussing more on pre-packaged insolvency resolution process. And we have the best of the faculty to discuss this topic. Advocate CA Ashish Makhija sir, a leading practitioner in insolvency and corporate laws, a big profile. But I will fail in my duty if I don't formally introduce Ashish sir. Sir is a leading practitioner and is a managing attorney of AMC Law Firm, a firm headquartered in New Delhi. He bears top credentials in corporate law, insolvency and bankruptcy law, corporate litigation, and advisory. He was the standing counsel for the official liquidator attached to High Court of Delhi for 6 years, handling many large-scale cases of corporate insolvency and liquidation. He regularly appears before Supreme Court, High Courts, NCLAT, NCLT in insolvency, bankruptcy, corporate law, and arbitration matters. Academically brilliant, Sir was awarded gold medal by CBSE for obtaining 100% marks in mathematics. He is a rank holder throughout in CA final exams as well as LLB exams from Delhi University, and also heads a magna cum laude in LLM from USA. Sir is a fellow member of the ICAI and has also insolvency professional pursuing PhD in law from Amormi School of Law, Atlanta, USA. Sir has authored many books. Sir is a avid contributor of articles in journals and online portals of the repute. He has contributed to Indian Law Reports, a law report published by High Court of Delhi from July 13 to May 16. He regularly writes blogs on professional topics at ashishmakhija.net. He is a distinct follower he has his distinct followers for writing skills. He has significant corporate board experience and has served as an independent director in Shipping Corporation of India Limited, Caterpillar India Limited, and other public and private limited companies. Sir is a keen golfer and has won coveted hole-in-one trophy as well. All-rounder, multifaceted personality with his expertise in the domain. Sir, we welcome you. I see Amruta Kulkarni, Vice Chairperson of Pune branch of ICI. Take great pleasure to welcome you on this virtual platform. The stage is all yours, sir. Over to you.
Thank you. Friends, first of all, a very good morning to all of you. I think what an exciting program has been started by the Pune branch of ICI. I must congratulate the entire team, including Amrita ji and other team members. Once people need to be trained, you see, to pass the exam, it's not a simple exam as it was earlier. Naturally, the chartered accountants and the fraternity members need a lot of support, a lot of guidance is required. And I think Pune ICI has taken a step towards that, and I must compliment them for taking these steps. Particularly organizing a 5-day program is not easy, coordinating with so many faculty members and then organizing such programs on the platform. I think hats off to them. So friends, we must appreciate their efforts. That's number one. Number two, I think I also really appreciate the decision of the chartered accountants and the fraternity members to take this step. Well, passing an exam after 15 years of becoming a chartered accountant, or 20 years, or maybe 25 years or 30 years is not easy actually. And somebody used to tell me when I used to encourage people, they said, sir, agar main fail ho gaya to bachon ko kya muh dikhaunga? Kind of a situation that always happens. But anyhow, if we can pass a CA exam, I think nothing is difficult for us. So friends, with these objectives, I'm sure you had a fantastic training for the last 2 days. This, I believe, is your 3rd day. Well, friends, before we come on to the topic, I think I've given extensive, training in limited insolvency examination, and I'm very proud to tell you that out of 3,500 IPs, probably more than 2,000 plus, or maybe 2,500, I would say, have been trained by me in at one stage or the other. And I am really happy that with the guidance they could pass, and they actually scored really very well. So friends, here your target should also be, once we do these kind of trainings, when I come for that, because I speak to the IPs, otherwise also advanced training on behalf of IBBI and many other programs. When I come to such kind of trainings, I always tell people who are doing this, I said, please, you may ask any number of practical questions, but here your focus should be only theory. Your focus should be to pass the exam. So friends, please concentrate, look forward to the, read the IBC, read the code, read the rules, read the regulations, try to remember, because not, lot of questions are coming on the time limits. In how many days adjudicating authority should pass this order? So 14 days, 10 days for IBBI. So many other things are there, so which you need to remember. Well, the exam pattern is like that. I mean, we can't really help it. Of course, there are case laws and then case studies, which are more practical. Definitely, the concentration is there. But unless you understand theory, unless you understand case laws pretty well, I don't think anyone can do the case studies. So don't jump to case studies straight away, my dear friends. Theoretical portion is extremely, extremely important. Okay, so now let us look at, okay, somebody is saying my voice is low. I don't know whether I'm really audible, or is it okay?
The volume is bit low.
I don't know what is the problem, because, yeah, Sandeep Singh ji is saying it is fine. I don't know. Because I'm using an external mic also. I think typically it is fine. I don't know. There is some problem. Okay, anyhow, maybe I can request everyone to please increase the volume. I think that should be better. Okay.
Yes, sir. Fine now. Fine.
Okay, so now friends, let us straight away go to, if you have any questions relating to limited insolvency examination, I mean, how to strategize that and all that, we can definitely discuss at the end, maybe for last 5-10 minutes. But I think whatever you see topic is there, I think we need to cover that. So friends, now I've got a PPT made on this, but let me also discuss, you see, otherwise, what I request is, friends, what you need to study is, you do not require any book for limited insolvency examination. What do you require? You require a bare act like this. I'm showing it on your screen, a bare act like this. That's all. I mean, you can download as a PDF version, but I being a conservative, I would like to spoil the book also by underlining, by highlighting, and then remembering. Because so what I suggest is, invest in this book, spoil it for the limited insolvency examination. And it is extremely important that you should do that, because reading from a book naturally helps rather than reading from a PDF. Now, if you are used to reading from a PDF and marking and highlighting, well, that's also fine. Now, friends, let us also try to understand that what is this PPIRP? Today, we are going to talk about pre-packaged insolvency resolution process. And in short, what we call it as PPIRP. I think my friends are aware that there are, you see, few processes which are there. The IBC, let us try to understand. I think you must have read it so far. But to understand IBC let me give you a helicopter view. IBC is divided into 5 chapters, that code. 5 parts, not chapters, 5 parts. Now, the part number 1 is that talks about preliminary, which is containing only about 3 sections, sections 1, 2, and 3. Typically speaking, if you look at the any law of India, any statute of India, you will find definitions in section 2, isn't it? You take Companies Act, Income Tax Act, or any other act, you will find a lot of definitions in section 2. But here is an exception, my dear friends. IBC contains definitions in section 3 and not in section 2. In section 2, it talks about application, to what entities or to whom this IBC is applicable, right? So if you go through that, then you will get to know that it has got a lot of provisions, parts to it. So this is applicable to those entities or persons. But section 3 gives you definition. In fact, this is a unique code where definitions, my dear friends, are not given in one section, there are 3 sections. As I mentioned, part 1, sections 1 to 3. Section 3 contains definitions. Then we come to part number 2, which gives us CIRP, Corporate Insolvency Resolution Process, and Liquidation Process. So these are the 2 processes which are covered. Naturally now, of course, we have PPIRP also inserted in part 2 itself. So anyhow, but the heading remains same, CIRP and liquidation. And if you look at section 5, which falls in part 2, it also contains definitions. Then we will move on to part number 3. Part 3 talks about the individual insolvency and insolvency resolution process of the individuals and partnership firms, And then in case the process is not successful, then we are talking about bankruptcy. So just please note, this is very important. The heading of part 2 and part 3. Heading of part 2 says CIRP and liquidation. Part 3 says insolvency resolution process. Naturally, the word corporate will not be there because it's not for corporate. And then it uses the word bankruptcy. It does not use the word liquidation. So this is a minor difference which you must note. And then we move on to part 4. Part 4 is typically for regulatory provisions are there. It talks about IBBI. It talks about 3 kinds of service providers: insolvency professionals, insolvency professional agencies, and then information utility. So their power, functions, duties, all those stuff, regulatory, that is contained in part number 4. And part number 5 is a miscellaneous part, which contains typically the standard sections like rule-making powers or regulation-making power, and other miscellaneous provisions which are relating to whether limitation law is applicable, all those stuff which is mentioned there. Now, I mentioned to you that there are 3 sections which contain definitions. First one was section 3, which falls in part 1. Second is section 5, which falls in part number 2. And third is section 79, which falls in part number 3. Now, you must be wondering why there are 3 sections for definition. Well, that's very simple, my dear friends. In a broader analysis, please understand, definitions contained in section 3 are general definitions, and they are applicable throughout the code. They are applicable for part 1, part 2, part 3, part 4, and part 5. The specific definitions which are contained in section 5, they are applicable only for the purposes of part 2. And similarly, section 79, which falls in part 3, the definitions contained in section 79 are specific definitions which are only relevant for the purpose of part 3. So therefore, we have got 3 different sections and defining various terms. Having said that, one more thing I can mention broadly before I move on to the subject of the day. If you look at IBC, my dear friends, you will find, typically speaking, you will find 2 phrases which have been used throughout the code. The first phrase is as may be prescribed. Now, if you want to write down a formula, friends, you can write down on a piece of paper, as may be prescribed is equal to rules is equal to central government. Just write down this formula. I'll explain it to you in a little while. Then there is a second phrase which is used throughout the code, and you will find at several places the phrase which is used is as may be specified. First one as may be prescribed. The second one is as may be specified is equal to regulations is equal to IBBI, stroke board or regulator. Now, what does this mean? This means that wherever you find, my dear friend, now this is the style of reading and passing the exam. This is also very important. And of course, from the practical point of view, later on also, once you become an IP, whenever you are reading a section, and this is what I also suggest, I can give you another tip, that before going for an exam, my dear friends, you need to make 3 readings. You need to make 3 readings of the IBC. And I call it as stop, look, and go. So unless you read it 3 times, you are not able to grasp it. Now, once you are reading a particular section, now sometimes it say, and I'll give you an example, like section 7. If you look at section 7, subsection 2, it says the application under subsection 7.1 shall be made in such manner, in such form, accompanied with such fees as may be prescribed. Now here, my dear friends, what I need to do. What do you mean by such manner, such form, such fees? Naturally, this power has been delegated by the Parliament to the central government. That means as may be prescribed. As may be prescribed means who is going to prescribe? The central government is going to prescribe. And central government will prescribe by making a set of rules. So here you will stop at section 7, subsection 2. You will go to a particular rule, find out what is the form number, find out what is the manner, find out what is the fees to be paid. So as may be prescribed is equal to rules, and rules are typically framed by the central government. And in our case, it will be Ministry of Corporate Affairs. Once this application process is admitted, like section 7, 9, 11, right? We are all aware that there are three people who can make applications: financial creditors, operational creditors, and of course, the CD itself, section 7, 9, and 11. Here, once this 7, 9, and 10, I'm so sorry. So once these applications are made, then if the order for CIRP is passed, that means the CIRP is commenced, then, my dear friends, from section 13 onwards, typically speaking, you will find the phrase as may be prescribed. Now, as may be prescribed means the process has started. Now, you will be bound by the regulations. So wherever the word as may be prescribed comes, like a public announcement must be made in the manner as may be specified. So as may be specified means here the regulator will specify in the form of regulations what is the form number or what is the format of that form. So all those things you will find in. So once till the time the CIRP starts, rules will, you see, have more effect. But once the CIRP process begins, you will have to look at the regulations. So rules and regulations, both are delegated powers of legislations, and as may be prescribed and as may be specified. These are two wonderful terms. You'll have to stop there, look for a particular rule or a regulation. So this is the way you should be reading it. Now, let me share my presentation for today. That is for the PPT just let me see if I can share it. Okay. I hope you are able to see the presentation now, my dear friends. Yeah.
Yes, sir.
Yeah. So friends, let us start in the right earnest. That is the pre-packaged insolvency resolution process, what we call it as PPIRP. Well, this is a kind of a unique name which was given. So the words pre-packaged. And if you have any questions, friends, probably, I don't know if we can unmute yourself or you need to ask on the chat box or whatever way you want it, you please do that. Now,
participants can raise the hands and the technical team will unmute them.
Yeah, okay. I think just keep an eye because I'm actually looking at the presentation right now. But anyway, let me finish some of the topics before the questions are raised. So friends, let us have a small background. See, this is also one of the important aspects. Friends, if you are targeting passing the limited insolvency examination, it is always better to understand the background of it. And this is another tip I can give you. Before even starting reading IBC, I will request all my friends here to at least go through and read the genesis of the IBC, which is BLRC report. That means Bankruptcy Law Reforms Committee report. Before this bill could be introduced in the Parliament, under the chairpersonship of Dr. Vishwanathan, a committee was formed, which was known as Bankruptcy Law Reforms Committee. They submitted their report, and their report is available on the website of IBBI and MC also. Please download it and please read it. It is a must read. If you are not able to read the full report, but at least please read chapter 3, 4, 5, 6. They are absolutely relevant. So it will give you kind of the basis why IBC has come. Of course, some of the things which were mentioned there, they have actually been amended in the law now, but it still makes a very good reading. Similarly, once the bill was passed and it became an act, the government actually appointed an insolvency law committee that is known as ILC, Insolvency Law Committee. and which considers amendments to the act. You see, once it has been passed, so it does it on a periodical basis. So on the basis of their reports, some amendments took place in 2018 and some have taken place later on. Similarly, there was a subcommittee of the ILC which was formed, you see, sometimes in June, and then under the chairpersonship of the Dr. M.S. Sahu, who was the chairperson at that time of IBBI. So 24th June 2020, the committee was formed. Then they submitted the report on 31st October. This was all done during this, you can say, COVID period. And I'll give you some background. And then public comments were invited in January 2021. And then, of course, it got implemented from 4th April 2021. So this is the date, 4th April, when the sections relating to PPIRP were notified. And later on, the rules and regulations were notified on 9th April. So these are few dates which probably are important. But what is the background? Why this new chapter, or particularly a new concept of PPIRP, was introduced? Was CIRP not successful? What was the reason? There were 2-3 reasons, my dear friends. The first reason was that during COVID period, all of us remember that the lockdown was announced effective from 25th March 2020. One day prior to that, the government thought that if we announce a lockdown, naturally the business will be closed and most of the companies will not be paying to their creditors, and there will be a lot of defaults which are going to happen. Now, and this will bring in the spurt of insolvency of these companies. So what they did on 24th March 2020, one day before, they raised the threshold limit. Initially, under Section 4, the threshold limit was only 1 lakh rupees. But on 24th March 2020, so for your exam purposes, naturally now the limit stands increased to 1 crore rupees. So they thought that if we increase the threshold limit from 1 lakh to 1 crore, the number of cases will naturally reduce and it will protect what the MSME sector. That means the micro, small and medium enterprises. Because in that the amount of the default and the debt is not very high. So therefore, they thought that this is going to protect. And two, there was another aspect which was very important. Once the CIRP starts, I think most of you are now aware about the CIRP process. Once the CIRP starts, my dear friends, what happens? Mark my words, most of the promoters remain ineligible under Section 29. I'm saying most of them. Some still may be eligible, right? But once you have committed a default, your accounts are NPA, naturally, most of the promoters are hit by clause number 29A, C, 29A, H, and many other clauses also. But C is, of course, the most dangerous one. So therefore, what happens? The promoters, generally speaking, they lose the company. Somebody else will file a plan and somebody else will win, unless he brings in now 12A and withdraws and all those stuff, of course, is there. I mean, these are all subject. But mark my words, in CIRP, once the company comes into CIRP, 99% of the cases, the promoters will lose their company. Somebody else will become a promoter. And now this was a problem in, MSME sector. What was happening? For an MSME, supposing I have invested only, say, 3 crore rupees, I have got 1 or 2 lathe machines and I'm doing some production for, say, some large industry. Now, tell me, if I come into insolvency, who is interested in buying me? So for MSME sector, if we look at the statistics at that time, 95% of the MSMEs were going into liquidation because nobody was filing plans for them. Now, this was a typical problem for MSMEs. Promoters were not entitled to submit their plan because they were defaulters. So the government, actually what they did, now they took one of the steps initially when they introduced Section 240A, subsection A, right? Not subsection A, 240 capital A. Now, which is giving exemptions to the MSME sector from the applicability of eligibility conditions under Section 29. So if you look at Section 240A, so some exemptions are given to the promoters of the MSME. That means they still become eligible despite the fact that they have NPA in their account. So 29AC and 29AH are not applicable to MSME sector. So this was one protection given to MSME. But the second protection was also thought that, look, why can't we have a pre-packaged process? Because this is the process followed in some other countries. Now, somebody may ask you, or somebody may have a doubt in mind that, well, OTS is also there, one-time settlement. What is the difference between OTS and pre-packaged PPIRP? Or what is the difference between CIRP and PPIRP? So that's a good question. So let's look at this. PPIRP, my dear friends, is a hybrid mode of resolution. OTS and CIRP are on two extremes. OTS means that the promoters concerned or the management of the company enters into a settlement with individual financial creditors, individual borrowers, isn't it? Supposing there are 5 banks, you have taken loans from 5 banks, naturally you will have to enter into an OTS with each of the banks. Or if it is a consortium, naturally you will have to involve all and then enter into it. But then you might have taken a, private loan also, or a loan from vehicle also. So you will have to talk to them separately. So OTS and in any case, OTS is not mandatory, in the sense bankers are a little wary nowadays, and they may or may not accept your OTS proposal. So there, the chances of the company becoming insolvent is very, very high. And the process naturally is not a time bound. It may take 6 months. It may take whatever time. So this is one extreme. But one of the important aspects of OTS is that the management still remains in the saddle. Who runs the company? The same promoters. While they have submitted OTS, the control of the company remains with them, right? So we call it as the debtor-controlled company. But in CIRP, on the other extreme, we say that the control shifts from debtors to creditors, because now once the CIRP starts, another person is appointed who is known as insolvency professional. He takes over the control and he works under the supervision of the COC. So COCs are nothing but the creditors. So this is a creditor-controlled company. Now the promoters have no role to play, because the powers of the board of directors vest with the insolvency professional under Section 17. So therefore, there is a transfer of a shift of power. So that is another extreme. So promoters are out and then the resolution is happening. But now they thought that, why can't we have an hybrid mode? While the promoters still run the company, but let us have a plan similar to what the resolution plan which comes under the CIRP process. And this will help that promoters will have better confidence. They are running the company while this plan is being considered. And if the plan is approved, naturally, they will retain the control. So they will not lose control. So this is like a hybrid. And in case, but there is an exception which has been provided, that in case the management of the company, while the PPIRP plan is being considered, they commit some fraud, or they do still indulge in some other activities, diversion or other things, then the process of PPIRP can be converted into CIRP. Or secondly, the management can also be vested with the insolvency professional at this stage. So it can become another CIRP, or it can be that their powers can be curtailed and the powers can be exercised by the RP and other people. But here, the point what I'm trying to say is that initially the model is like this, that the control and the power remains with the management. And the resolution professional who is appointed, he has got only supervisory or monitoring powers initially. But if the COC decides that management is doing some default or doing some fraud, then they can transfer the management also to the RP. But still PPIRP will continue. Or they can take a call that let's convert it into CIRP, which can also be done. But till the time it is converted into CRP, it is known as a PPIRP process. So anyway, this is what I've given you broadly. But this was the purpose of, it's a hybrid model. That is what I'd say. And the committee also mentioned that it is like an out of court kind of a settlement. So this can also be done speedier resolution. So the resolution will be faster because the time periods are little even faster than what we have in CIRP. But still there are checks and balances. Though the management is is still controlling, but they are under the checks. They are under the monitoring of the resolution professional, right? And this is one of the option of resolving insolvency. So court monitor is typically, we call it a CIRP process, which is court monitor. Then scheme of arrangement, the companies can go for under section 232, 232 scheme of arrangement, mergers, amalgamation also. And out of court, as we understand, is depending upon the negotiation, that OTS, and RBI has also issued some prudential norm for stressed assets. So those needs to be followed. Now, this is what, as we have already discussed, this is a hybrid formula. Here, the stakeholders are empowered to resolve the stress of the CD as a going concern. Now, this is very, very important. And secondly, the objective was that there should be minimum interference of the adjudicating authority. So here, a lot of freedom and other things are given to the COC and other persons or the promoters itself. The interference of judiciary is typically lower in case of PPIRP. So initially, it was introduced through an ordinance. Later on, of course, the insolvency bill was introduced and then it became an act. Amendment Act was passed. Now, friends, these are few dates which are important. Sometimes a question can come on this also. So these are applicable effective from 4th April 2021, right? 19 sections were added, my dear friends. Initially, you know that IBC when it came, it contained 255 sections. More sections were added later on. Some more sections, I believe you are aware of those. So sections like 240A, 238A, 12A, and many other sections which are the 25A, all those sections were added. But the major number of sections were added in this amendment, 19 sections. And today, we have 282 sections in all in IBC. So 54A to 54P. Now, these were the, you see, chapter 3A was added in part number 2, which talks about pre-packaged insolvency resolution process. And then some consequential sections were also added, like 11A was also added. 67A you will find is a new section. Then in penalties section, you will find 77A. So these were all around 19 sections were particularly added. Now, and as I mentioned in the beginning also, that pre-packaged insolvency resolution process rules were also notified, and they were notified effective 9th April. Similarly, regulations were also notified effective from the same date. Now, one more important aspect that for the PPIRP process, the minimum amount of default, my dear friends, is not 1 crore rupees. The government has issued another notification, and for PPIRP purposes, if it's an MSME, because it is applicable only for MSME right now, the notification was issued under section 4 for the threshold limit, and now the threshold limit is 10 lakh of rupees. So minimum default must be 10 lakh of rupees. If any MSME wants to come under PPIRP process, and PPIRP process, my dear friends, is a choice, is an option, right? So it's an option, so which is to be dealt with. It's not mandatory that everyone has to come. Well, if you can have a discussion with the financial creditors, you can have them in confidence, because this cannot be done without their confidence. So please understand, it's like a modified OTS given the statutory, you can say, coverage like this. So, but it is a process of negotiation. So if the financial creditors do not agree, they do not permit you to start the PPIRP process, because even to start the process, you need their permission. In fact, there are 3 stages. I'll just take you to that particular stage. So let's take the overview of the process. Overview of the process is, as I mentioned, there are 3 stages. First stage is known as pre-PPIRP. So right now, PPIRP has not started. But Here, the corporate debtor, the company or the MSME has to take certain steps, has to take financial creditors in confidence. It cannot be done, my dear friends. Please remember, it cannot be done without their concurrence. So if they don't permit you to start, then you don't have this option. So naturally, you have to build the confidence of the financial creditors that you have the money power also to do it. But of course, you are financially right now strained, but you need some time to get over with that. Then once the PPIRP process starts, that second stage will be PPIRP without management vesting. That means here the management will be in the control of the existing management. So nobody is coming over and taking over your assets as like in CIRP. So this will continue. But there is a stage where if the COC feels that the management is running the company not in a proper manner during PPIRP, please understand, PPIRP is already started, but the COC is not happy with the running of the management, then they can say the management will now vest with the resolution professional. So that will be the third stage if it comes. So it may or may not come, right? So PPIRP without management vesting, which is a normal PPIRP, but PPIRP with the vesting of the management with the IRP, because COC may take a call on that. So this is very important. So the process, how it starts, my dear friends. So let's try to understand. This is very important. And all these sections, my dear friends, what I suggest is if you can have a blank piece of paper before you, and if I can request someone to keep this particular IBC in front of them, and they can read the headings, you see, along with me. I think I will request somebody, and maybe is anyone there who can help me on this? Just I want you guys to read the headings with me, so that at least we are doing, because I just don't want to speak and just go back. Yeah. Okay. Okay. I think Sandeep Singh ji is saying that he will be able to do that. Even Lakshman, Mr. Lakshman has also mentioned. Okay. Thank you, friends. So maybe I'll request the organizers to unmute one of them or maybe both of them. So just read the headings and I will explain you in very briefly, and then we'll go in detail. So first I'm going to take you as an overview of the process. So friends, default amount has to be checked. What is the threshold limit? Because supposing a client comes to you, he says, I would like to go into PPIRP. Now you have to cross certain bridges. The first bridge which needs to be crossed is, number one, have you committed default? If the corporate debtor says, yes, I've committed default, then the second question which you will ask is, what is the default amount? If the default amount is not less than 10 lakh of rupees, only then the person is eligible for PPIRP. So this is the default amount. Section 4 naturally has to be read along with this. Now, friends, all these sections, what I suggest is make 3 columns. And in the first column, you write down the section number, like 54A. I'm going to start with 54A. Second column, just write down you can say the heading of section. And third column, I'll just give you an explanation so that you will be able to recall. Otherwise, it becomes very difficult during the exam what section talks about that. So I'm just going to give you an idea to keep it for easy remembrance, right? I'm just going to give you some links on that. Okay, so let us go to section 54A. Okay, can somebody read the heading of section 54A? Sandeep ji, if you are unmuted, or anyone who is unmuted. Okay, I don't know whether you are unmuted or not.
Madam, Sandeep Saranna unmute kara.
Okay, Sandeep ji, are you unmuted or still not? Maybe if you can write on the chat box. No, okay. Okay, anyway, by that time he's unmuted, let me read that. 54A, my dear friends. What do you mean by A? Now, for easy remembrance, A is like applicability. So you can remember A with the word applicability, right? Now, what is the exact heading? Exact heading is corporate debtors eligible for prepackaged. So it talks about eligibility. So eligibility is equal to applicability, right? Whether to whom it is applicable, right? So 54A, you can easily remember with applicability stroke eligibility. So that is what it is there. And we'll come to that in detail in a little while, but let us go through these you see sections. 54B, my dear friends. Now 54B, yeah, okay. I think Mr. Lakshman is unmuted. Are you unmuted, sir? Okay, anyway, I think there is some problem. So let's go further. 54B, my dear friends, what it talks about. Now, it talks about the duties of the RP before initiation of PPI-RP. So remember B with before initiation. So B stands for before, right? Before initiation of PPI-RP, still there are certain duties of the RP. Because here the RP is to be appointed. You have not been appointed so far. And adjudicating authority does not come into play. Of course, they will appoint you later stages, but first you have to be selected. So duties of the RP before initiation of PPI-RP. So B stands for before initiation. So just remember that so that tomorrow you are able to place that section easily. You see, once comes going to the examination hall. Now, then comes the 54C. Now, C, you can link it with commencement, right? C, you can say commencement. How will it commence? When you move an application. So in under 54C, application is to be made, like similar to section 7, 9, and 10. So you have to make an application. Somebody has to make an application. And naturally, corporate debtor will make an application. Nobody else is entitled there. So 54C is like commencement of CIRP. Naturally, that commences with the making of an application. Okay. 54D, my dear friends, D stands for duration. So what is the time limit? So D gives you the time limit. If you look at the heading of D, it talks about time limit for completion of PPI-RP. Now, what does that mean? Time limit means duration. So 54D is equal to duration. So remember that. What is the time limit within which this PPI-RP is to be finished? Naturally, for CIRP, we know it is 180 days plus 90 days extension plus another extension of 60 days. So it's overall 330 days. But my dear friends, remember, insofar as PPI-RP is concerned, the overall time limit is 120 days, including the approval of the plan by the adjudicating authority. Typically, it is divided into two parts, 90 plus 30 days. So 120 days. So time limit is 120 days. Okay. And then let us go to 54E. I believe now Sandeep ji is part of the panel now, right?
Yes,
Yeah. Sandeep ji, can you just read 54E heading?
yes, sir. Declaration of moratorium and public announcement during PPI-RP process.
Yeah. So E stands for exclusion of time. Because moratorium is like standstill period. Time is excluded, right? The time does not run for certain purposes. So moratorium. So just E, you can link it with exclusion of time. Just I'm giving you a style to just keep on remembering. That's all. Otherwise, the heading of the section says moratorium. I'm saying that moratorium is nothing but exclusion of the time. Then let us come down to 54F. Yes, sir. Can you read the heading, please?
Yes, sir. Duties and powers of resolution professional during the PPI-RP.
So duties and powers, if I combine and take a one word, F stands for functions. So functions of RP during PPI-RP now. Please understand, we had two sections. First was before PPI-RP. 54B talks about the duty of the RP before PPI-RP begins. But once the PPI-RP begins, naturally his roles, his powers and duties are different. So let us use one word, 54F. F stands for functions, and functions is equal to duties and powers. Okay. So we can generalize this. Okay. Yes, please go ahead to the next one, sir.
List of claims and preliminary information memorandum.
Yes. So claims and preliminary information. So it is talked about in 54G. Now, well, G stands for the groundwork, isn't it? Once the PPI-RP starts, some groundwork is to be done. Claims and then preliminary information memorandum. So that is also required in this case. I'll explain you. We require information memorandum in case of CIRP. We may have to get that ready, that information memorandum, which is known as preliminary information memorandum ready. So this is also very important. So groundwork to be done, at the time of the PPIRP, because here that it is very time bound. So within 2 days of the PPIRP, the information is to be submitted. The list of claims and the preliminary information memorandum is to submit it to the RP. Now that's also very important. Yes, sir. Please go to the next one. 54.
54H.
Yes.
Management of affairs of corporate data.
So here H stands for handling. How to handle the corporate debtor. So handling of the affairs or management of the affairs. So right. So H stands for handling of the affairs. And you can link it with the management of the affairs of the corporate debtor. So how to handle that during the PPRP process. This is what exactly 54H talks about. Yes, sir. Please go to the next one.
54I. Committee of creditors.
Committee of creditors. So what instructions can be given? So I stands for instructions. Who is going to give instructions? Link it with COC, isn't it? So instructions by the COC. So committee of creditors, how it is to be formed, within how many days, what are their powers, how they're going to deal with that. So those kind of things are mentioned in what? 54I. Yes, sir. Please go to the next one.
4J. Vesting of management of corporate debtor with resolution professional.
Friends, mark my word, this is the most dangerous section in PPIRP. Most dangerous. It creates a jeopardy, right? J stands for jeopardy. Vesting of management. If the management does not do the things in a proper manner, they are in a jeopardy. They are in trouble. So therefore, 54J is going to be a trouble for them. Vesting of the management with the RP. So now COC has lost confidence in the management. They say, sorry, you have manipulated the process. You have started PPIRP for fraudulent purposes. You are not genuine people. So therefore, now we are saying that the management will vest with whom? The RP. So I always call it a jeopardy section. So it is a dangerous section for the corporate data. Yes, sir.
54K. Consideration and approval of resolution plan.
Well, this is phonetic. C for consideration or K for consideration, isn't it? So phonetically remember that consideration and approval of the plan. So when the plan will be considered, so 54K. Now this is the heart and soul of the entire PPIRP. This is one of the longest sections, my dear friends, and you will have to read it extremely carefully because the entire process, which is little complicated. I mean, it seems to be complicated at the first blush, but if you understand it very well, I think then it becomes easier. But it is one of the longest sections. It contains 15 subsections and then explanations and a lot of other issues are there. So K stands for consideration, okay? Or C for consideration, right, sir? Please go to the next one.
54L. Approval of resolution plan.
Yeah. So L stands for let's do it. We have all done the whole process. Let's finish the process. Approval of the plan by the the adjudicating authority. Naturally, once the plan is approved by the COC, it goes to the adjudicating authority, and adjudicating authority will definitely not waste too much of time in approving such plans. So let's do it. Okay. So L stands for doing it. Let's do it. Okay. Yes, sir.
54M. Appeal against order under section 54L.
Well, M stands for major objection. So if somebody has objection, somebody is aggrieved, naturally you can file an appeal against that. So appeal against under section 54L, because order is passed under L. So therefore appeal is the next section, naturally 54M. So we can say major objection. So if somebody has an objection against that. Okay. Yes, sir. Please go to the next.
Termination of PPRP.
Termination. Termination is like N stands for no. So, I mean, we are not happy. So terminate the PPRP process. Convert it into CIRP, or we say, sorry, it was a wrong process. We are terminating. And there are certain grounds for termination, and there are serious grounds, my dear friend. So it's also one of the important sections. So 54N. Yes, sir. 54O.
Oh, initiation of corporate insolvency resolution process.
So initiation of the CIRP. Look at this. So O stands for original process. Original is what? CIRP is original. We gave a hybrid model of PPRP. We are not happy with the PPIRP. Something is wrong. The COC says, sorry, original is better. So let's go to the original CIRP process. So they can initiate CIRP also at any point of time. So O stands for kind of original process, right? Okay. Yes, the last section, sir.
54P. Application of provisions of chapters 2, 3, 6, and 7 to this chapter.
Right. P stands for provision. So applicability of other provisions. So how will you conduct PPIRP? Naturally, the process is quite similar. Some portions are similar. So the law says, oh, in the original process of CIRP, those chapters 2, 3, 7, and 6 and 7, some sections will still be applicable to PPIRP process. So read carefully. And it clearly says that certain provisions of sections like 24, 25A, 26, 27, 28, 29A, 32A, 43 to 51, which is avoidance. Well, all those are applicable also to PPIRP. Rather than reinventing the whole wheel again, or rather than repeating the same sections again here, the IBC says, let us rely upon earlier sections which are already there, subject to, of course, the relevant modifications are there. So P stands for provisions applicable to PPIRP of the original process. So these are the sections, my dear friends, for you. So I just gave you a hint just for an easy remembrance. That's all. Of course, you don't have to mug it up, just to understand, right? So that tomorrow there is no problem. And of course, you will have to read 67A, which is, you see, a new section which has been added after 65, 66, 67. Basically, 67, if you read, it says fraudulent and malicious initiation of CIRP process. Because CIRP can be started not for the purposes of recovery, but it has to be started with a genuine purpose of resolving the insolvency of the corporate debtor. There's a huge difference between recovery and insolvency resolution. Here, the creditor is saying, okay, my money is stuck. That's all right. I'm not asking for my money to be paid. I'm saying, please resolve the insolvency of the corporate debtor so it benefits all creditors. Naturally, that's a process which is to be started. So, but if somebody starts with the fraudulent and malicious initiation intent, he can be punished under 67. And a few orders have been passed under 67 when in one of the cases, ICICI Bank was imposed a penalty of 10 lakh of rupees also. And there have been few more instances. So therefore, similar section has been inserted for the 67A, which talks about fraudulent management during PPRP. That means you have initiated for a fraudulent purpose. You are doing it fraudulently. So who is going to be challenged? The CD or their officer. So 67A, if there is a fraudulent management during PPIRP, then they can be penalized. So this is also important. And if they give a false information at the time of starting of the process, then there is a penalty also. That means there is a punishment. They can be behind bars. And new section was added, 77A. Earlier, if you look at the last section was 77, but now in part 2, the last section is 77A. So from 78 onwards, part 3 starts, right? 78 talks about that threshold limit and all, and then 79 gives you the definitions. So this is the way the chapter ends now. Okay, let's move forward now. Any questions till this time, my dear friends? If you have any questions, maybe you can put it in the chat box, raise your hand. Otherwise, we can move forward. Okay. Friends, what I suggest to you is I'm not going to read these definitions along with you, but it is important that you should read certain definitions. Now, the date of admission of the application by the adjudicating authority will be treated as ICD for the PP. So I call it as PPICD, pre-packaged insolvency commencement date. Under CIRP, we all know what is ICD, insolvency commencement date, when the order is passed by the adjudicating authority admitting the CIRP application. Similar is the case here. Once the application is admitted, right, then it commences. So this is very important, friends. Insolvency commencement date in case of pre-package is the date of admission of the application by the adjudicating authority. Then, of course, there is a definition of pre-package insolvency resolution process cost. So please look at that definition. I'm not going to read along with you, but this is also important. And then Prepackaged insolvency resolution process cost. Yeah, these are this is a continuing definition. Then preliminary information memorandum. Now this is also which I mentioned to you. Well, friends, there is a slight difference between CIRP and PPIRP. In CIRP, once a person like you will be appointed as an insolvency professional, what we call it as interim resolution professional, IRP, and then you are later on appointed as an RP, it is the duty of the RP to prepare an information memorandum. Now, what is the purpose of the information memorandum? I think you must have read section 29. Section 29 talks about information memorandum. Now, what is the task of the RP? The task of the RP is, he's a facilitator. The task of the RP is that he will start the process and he will bring on board certain plans. That means he will request certain outsiders to submit the resolution plan. So he becomes a facilitator. Now, who is that somebody going to be? On what basis I'm going to submit a plan? I'm not going to submit a plan just in vacuum. I need some information, isn't it? Supposing a Bhushan Steel is being sold. Now, Tata Steel, if it wants to apply to take over Bhushan Steel or say ArcelorMittal or any other steel industry, JSW or whatever, or Vedanta. So what do they want? They need information. Naturally, they have some information in the public, but unless and until they get some core information. So who is going to provide? Naturally, the RP is going to provide now. He is going to make an information memorandum. So this facilitates the prospective resolution applicants to submit the plan. So basics of the company, when the company started, what are the business they're doing, how many plants are there, what is the production capacity, any damn thing, whatever is known to RP, he will put everything in the information memorandum so that the RAs, resolution applicants, can do their due diligence. But so who prepares it? The RP prepares it. But in PPIRP, this is a process which gets started by the CD itself. So who should be responsible for preparing the preliminary information memorandum? So here the onus has been put on the CD itself. So it says preliminary information memorandum means a memorandum submitted by the corporate debtor itself. So they will themselves prepare. It's like a prospectus, right? You go to the public for say public money or for some public issue of shares. Naturally, the company issues a prospectus which gives everything, all information about the company under the sun, right? Financial information, legal information, or technical information, what all the information is there, and that has to be true and correct. And similarly, here the memorandum will be prepared by the corporate debtor, which will contain the relevant information for formulating a resolution plan. So what is the duty of the CD? CD will prepare it. So that is what I'm saying. In PPIRP, a lot of preparatory work is to be done. It can't be done in a day. So preparatory work is to be done. Memorandum has to be given and it has to be submitted within 2 days to the RP of the ICD. So the day the order is passed by the adjudicating authority, starting the PPIRP process, the corporate debtor gets only 2 days. So they are not preparing only in 2 days. Obviously, it is already prepared. But once that order comes, it is handed over to the RP. So this is known as preliminary. Why it is preliminary? Well, ultimately, who's going to finalize it? Naturally, the RP. Once the RP scans it, he will look at whether the information is correct or not, whatever his basis is, and then he will approve this, and then the information memorandum will be ready. But preliminary is to be submitted by the corporate debtor. And what is the period of the PPIRP? The PPIRP period naturally starts from, this is the beginning date, ICD. Insolvency commencement date is the period when it starts. That means when the adjudicating authority passes the order. Now it ends where? If the plan is approved, naturally the period will end. If the process is terminated, if there is some fraud going on, and adjudicating authority can terminate at any point of time. I'll show you that section. So termination can happen after 10 days, 15 days, 20 days, whatever. So if it is terminated, naturally the term of the PPIRP comes to an end. Or the third is, you see, when it is shifted, when the CIRP, when it is shifted to CIRP, because as I mentioned, PPIRP may not go through the whole process, the company. Well, it can be converted into CIRP. So 3 processes will determine the time period: plan approval. And if not approved within a relevant time, naturally it ends automatically. Or termination, if it is done before that, termination is also possible at the end of the time period. And then, of course, either it is shifted to or changed to CIRP process. So this is the period of the PPIRP. Let us look at the process in detail, my dear friends. Okay. And other sections, naturally, you can read. I'll take you to few of the bullet points there. But I will deal with 54K in detail, because K is something which you need to really understand. Okay. So the process which we told you mentioned, you have to check the default amount threshold, and the amount which has been notified is 10 lakhs. So friends, a question can come on this. Please remember, for the CIRP process, the minimum threshold default limit is 1 CR, but for the purposes of PPIRP, it is 10 lakhs. So please read the question carefully. Don't simply read threshold limit and then start taking 1 crore rupees. You'll have to read, because they may write down for the pre-packaged insolvency resolution process. Pre-packaged. If you miss reading the word pre-packaged, then your answer is going to be wrong. What is the minimum default limit? 1 lakh, 10 lakh, 1 crore, none of the above. So you'll have to click nothing but 10 lakh rupees. Okay. The central government can definitely increase the minimum default amount limit to 1 crore rupees. They have got power, they have still not done it. So it is only 10 lakh rupees right now. Then the second is, because if we look at section 54A very carefully, now it talks about the, as I mentioned to you, eligibility criteria, right? 54A is applicability, to whom it is applicable. Now, if you read subsection 1, Sandeep ji, may I request you to just read subsection 1, sir?
Yes, sir.
Yeah.
54.1, right? So 54A1.
A1, yes, sir.
Yeah. An application for initiating pre-packaged insolvency resolution process may be made in respect of a corporate debtor classified as micro, small, or medium enterprise under subsection 1 of section 7 of the Micro, Small, and Medium Enterprise Development Act 2006.
Yes. So first of this section very clearly says that this PPIRP can be initiated by the CD, which is classified as MSME. So this is the first step which one has to do, whether you are classified as MSME or not in accordance with section 7.1. That is extremely important. So check those limits. If you are falling within those limits, well, you are an MSME. If you are an MSME, then you are eligible under 54A. Otherwise, you are not. This section is only restricted. This portion, PPIRP, is restricted only to MSME corporate debtors who have committed default. Those who have not committed default, naturally, they will not come under this. Now, the one question, you see, the practical question, of course, and that comes is whether registration under MSME Act is mandatory or not. Well, if you go, if I look at from a legal standpoint, look at subsection 1, which was just read by Sandeep ji. It says, in respect of a corporate debtor classified. It doesn't talk about registration. It says classification. If you go to section 7, subsection 1 of MSME Act, right, 2006, you will find that these are the classification criteria. So if you fall in that classification criteria, if they apply to you, if you satisfy them, that's the end of the matter. Udyam registration, which is there, is not mandatory, because if you look at form number 1, which is an application, right? Form number 1, because you will have to remember the form numbers also, and form numbers you will find in where, my dear friends? Rules. So go to the rules, find out those forms also. So as per form number 1, nowhere it says that you have to attach Udyam registration, because it does not talk about registration. If you go to MSME Act, registration section is the next section. It is not given in section 7.1. 7.1 only talks about classification criteria, right? So this is one of the important aspects which you have to see. Now, second is, of course, we'll have to see whether they have committed default. I think we have already done that. Now, The other processes are, the other conditions are very important. So what are the other conditions? The other condition is, if you look at condition number A, that such corporate debtor has not undergone PPIRP or completed CIRP during 3 years preceding the initiation date. So if the company has already undergone PPIRP or has already completed CIRP, right, 3 years from the date when you are trying to initiate, well, you're not eligible. So there is a cooling off period. Once you have completed CIRP, you can't, because at the end of the day, we are not, these provisions cannot be manipulated. You complete a CIRP process today and after 6 months you come in PPIRP, well, that's not possible. You are befooling the creditors then. You are not genuine. So therefore, there is some cooling off period. So what is the cooling off period? The period is 3 years. So this is very important. The second condition is it must not be undergoing CIRP. So if a company is already undergoing CIRP, there's no question of PPIRP. You can't say, oh, I am an MSME. My CIRP has been started. Stop the CIRPs. Let us start PPIRP. Sorry, that is not possible. If CIRP is already going on, you are not eligible for PPIRP. Well, and of course, if you are under liquidation, naturally, if you are already being liquidated, you cannot come back to PPIRP. And they must be eligible to submit a resolution plan under section 29A. And of course, 29A, my dear friends, I'll caution you, because of MSME, please read it along with 240A subsection 1, right? 29A is a dangerous section, talks about ineligibility. 29A, C, I, and H are very dangerous clauses. But if you go to 240A, there is certain exemptions for the MSME sector. So please follow that. That is extremely important. Okay. Then, now this is extremely important, friends. Here, if you look at clause number E talks about unrelated financial creditors. Financial creditors fall under 2 categories, related and non-related. You remember that under CIRP section 21, formation of the COC, who are part of the COC? Those financial creditors who are not related, right? Unrelated financial creditors are only constitute the COC. So in this particular case also, unrelated financial creditors have got power. So actually major role will be played by unrelated financial creditors. So for the meaning of the word related and unrelated, you will have to go where? Section 5, subsection 24 and 24A, right? So please read these 2 subsections for the meaning of the word related parties. That is extremely important. So here the financial creditors having 10% or more of the total financial debt. So remember this, my dear friends, 10% or more. Questions can come on this. I can't help it. You'll have to remember all this. So wherever any number, percentage, any figure comes, please, this is what I can suggest you. Have a different color highlighter you see available, readily available. Wherever you come across 66%, 10%, number of days or whatever, just highlight that. Because once you are going for the examination day, you can just scroll through those, glance through, and then it will catch your eye, right? So wherever you have highlighted, those portions will catch your eye and you will still be able to recall what are the number of days. Okay. So financial creditors, and naturally only unrelated, having 10% or more of the total financial debt may propose the names of the RP to be appointed, right? Because now here, the proposal of the name of the RP is to come. So because RP will play a major role in checking the application, in receiving the preliminary information memorandum, in receiving the claims, and so forth. His jobs are still there, but though he's not running the company, right? Then what will they do? After this names have come. Supposing there are 3 financial creditors who have more than 10%. So all of them can suggest names. So it's not that it is restricted. So there can be 3 names, there can be 5 names of the insolvency professionals. Then the corporate debtor, because right now there is no RP, please understand, he has not been appointed. His name is only been proposed. So now how is going to be appointed? So therefore a CD, corporate debtor, has to convene a meeting. We don't call it as a COC meeting because it's still the no COC is there. We will convene the meeting of the unrelated financial creditors, and they will pass a resolution for appointment of RP during pre-CPPIRP. And for the purpose of calling a meeting, go to the regulations, friends. 5 days notice is required unless shorter notice is agreed. So you'll have to remember these number of days. Notice is to go in form number P2, and I'm just skipping those forms numbers, but they are there. They're there on your screen. So you'll have to naturally mention the date, time, venue with a list of creditors and the amount due. So list of creditors, who's going to prepare? The company. Company knows it as per their ledger accounts. What are the outstanding amounts? So 10% will also be decided. The majority percentage will also be decided according to that. In that meeting, unrelated financial creditors will approve the name with minimum 66% majority in the value of financial debt. So 66% majority is required. Now, one question can come. Supposing there are no unrelated financial creditors, well, then the process will be taken over by the unrelated operational creditors. So related financial creditors have no role to play. So unrelated operational creditors, if you go to regulations, you will find those processes which are there. So answers you will find. But here, the majority required for approval is 66%. So once they approve the name, and along with that, so this is one step which the CD has to do. Take the names to be proposed by the unrelated financial creditors, minimum 10%. Then call the meeting, get the name approved, say it can be voted. So if the 4 names are there, 4 will be voted upon. And the person who gets more than 66% will be appointed as the RP for this. Here, my dear friends, another difference. In CIRP, initially the appointment is known as Interim Resolution Professional, IRP. Here, my dear friends, the person who is appointed is not appointed as IRP, he is straight away appointed as RP. Right? There is no concept of IRP in PPIRP. Okay, I hope I'm clear. And along with that, now, because PPIRP is being initiated by the corporate debtor itself, so naturally they require some self-declaration. What are these declarations? So declaration is to be given by majority of the directors. Form number is P6. You can go through those form numbers, but it will contain 3 declarations, 2 or 3 declarations. What are these declarations? Number 1, that CD will file application for PPIRP in definite time period not exceeding 90 days. So you get 90 days time, right, to file the application. Once the process gets started, so corporate debtor gets 90 days. And then within 120 days after the initiation, it has to be approved. So naturally we get maximum 90 plus 120. So the whole process can be completed within 210 days. But they can say we'll file application within 45 days, but it can't exceed 90 days. That's what I'm trying to say. Second declaration is that PPIRP has not been started to defraud it has not been done with an intent to defraud any person. So this is another declaration which and if this declaration goes wrong, it can be terminated. So look at these declarations. This is important. And the third is that the name of the IP has been proposed and approved. So if these 3 declarations are there, along with that, now there is a second thing which needs to be done. CD cannot start unless a special resolution is passed. In case it is a company, so we'll have to pass a special resolution to start the process. In case it is a limited liability partnership, then 3/4 of the total number of the partners must approve the filing of the application for PPIRP. So one is in-house. I must approve it in-house. If my shareholders 3/4 do not want it, naturally I can't start. So therefore, to start, you require 3/4 approval. That means special resolution in case of a company. Otherwise, if it's LLP, 3/4 of the partners must approve it. So these are the few things. So internal approval or by way of a special resolution, 3 declarations, proposal of the name, taking the name to the meeting, unrelated financial creditors with 66% approving that name, right? So these are the things which are to be done. Now, CD naturally will provide the declarations, the special resolution, and also the base resolution plan. So please understand, friends, that now the RP has been appointed. he will be handed over the declarations. He will be given the special resolution. He will also be given the BRP, base resolution plan. So therefore, BRP is not something which will be created later on, but it has to be a plan submitted by the CD is known as base resolution plan. I'll tell you why it is known as BRP. We'll explain it in a little while. But please understand, because here the corporate debtor itself is also giving a plan, right? Because they want their own revival or survival. So therefore, it is known as base resolution plan. Whether that base resolution plan is accepted or not, what are the consequences will come to 54K. That is in a typical section. But here that is to be given. Then approval to be given by, so all these documents will be given to the financial creditors, unrelated. And naturally, since the RP is there, now RP will supply all this. And they will call a meeting. And in that meeting, that will be a second meeting where now they require 66% vote of the unrelated financial creditors to start the PPRP process. So first, it is the internal approval of the company, declarations, appointment of the RP, and then base resolution plan. All these documents now will be sent to the unrelated financial creditors, and their meeting, another second meeting will be called, and that meeting will look at the resolution, whether we should approve the process to start the PPRP. They're not approving plan right now. They are only voting at this stage whether to start the process or not. So that will be given by this. So same process of the meeting will be followed, the date, time, venue, everything. And the job of the RP starts from his approval. So once he is appointed, then your job has started. And naturally, now you will coordinate the holding of the second meeting and all. And then he has to prepare a report also in certain format. Now, this report will confirm, because the financial creditors need to have confidence. And that confidence will come from the RP. And he will say that, yes, CD meets the requirement. That means you are an MSME, that it meets the threshold criteria. All declarations which are required under the law have been given. The CD is eligible. Otherwise, that means there is no PPRP going on or undergone it, or they are not undergoing liquidation, other things. So all those criteria he will check and he will submit. And BRP, base resolution plan, also confirms to the requirements. So it is only right now base. Nothing has been done. So he will submit a report, and that report will also be filed on e-platform. Basis on that, the financial creditors, unrelated ones, they will take a call whether to start or not. So duties of RP will continue till period to file PPIRP expires. So friends, as I told you, the first stage, pre-PPIRP, we are still in pre-PPIRP. PPRP is not yet started. So RP's role starts even before the PPIRP starts. So from the date of his appointment, he will continue till supposing an application has been filed, rejected. So his job is over. He files an application, it is admitted, his job is over. That means now his duties during the PPRP will start, but pre-PPRP period is over. Or 90 days expire. That is the time limit which has been given, and application is not filed or moved or approved by the CD. Well, the matter is over. Again, the PPRP ends without any consequences. So from this stage, company is running as a normal company, right? So somebody wants to start CIRP, they can start that. Anyhow, so application by CD in form number 1, declaration, special resolution, approval of the FCs, name and consent of the RPs to be attached. So naturally, after all these approvals, their application has to be made by the corporate debtor. And along with that, these declarations, their own special resolution, approval of the financial creditors, the RPs consenting to act during the PPIRP. So all those things will be there, right? And now along with that, my dear friends, one more declaration is to be given. And the declaration is, now it will say that regarding the existence of the avoidance transactions, whether the avoidance transaction exists or not. So CD itself is now saying whether avoidance transactions or not, right? And then adjudicating authority will approve or reject within 7 days, right? Typically, if you look at the CIRP process, adjudicating authority takes how much time, my dear friends? 14 days. Here, the time period is 7 days only. And if they admit it, then it is known as insolvency commencement date. And from that date, the entire PPIRP is to be completed within 120 days. So 90 days is pre-PPIRP date maximum, right? It can be less than 90 days because it is the company which has to say how much time it is going to take to move the application. But maximum time period allowed is 90 days. And once ICD starts, then from that date, it is only 120 days and no extension is possible, my dear friends. There is no provision in law, unlike section 12.2. Look at section 12, subsection 2 in CIRP, extension of 90 days is possible, but here nothing is mentioned. So 120 days. In fact, 120 days is also divided into two parts. Within 90 days, the plan is to be approved. Then it is to be placed before adjudicating authority. And adjudicating authority gets 30 days to approve it. So 90 plus 30 is also, 120 is also divided into two parts. So RP to submit approved resolution plan within 90 days. Look at this. And in case no resolution plan comes or is approved within 90 days, then it is the duty of the RP to file an application for termination after expiry of 90 days. Look at the serious conditions. No extension possible. You submit within 90 days, done and dusted. If you don't, then the application is to be filed by RP for termination. And then if you look at the moratorium part of it, so section 14.1 and 14.3 apply in a similar manner. So if you look at the moratorium section, very clearly it says that the moratorium, as mentioned in 14.1.3, those provisions shall apply mutatis mutandis to the proceedings of this chapter. So therefore, same provisions are there. Then RP will naturally be appointed by the adjudicating authority. A public announcement will be filed in, will be made in form number P9. And just look at the regulations. There are slight different regulations are there because public announcement, the word public announcement is there, but there is no publication here. It is to be given on the website of the IBBI, website of the corporate debtor and all. So just look at some provisions are different than CIRP. And then moratorium period, as I mentioned earlier also, starts from the ICD. And when it will end? When PPIRP ends. And when will PPIRP end? Three conditions I mentioned earlier. Approval of the plan, termination, or conversion into CIRP. So that is the period of the PPIRP. Okay. So RP will conduct PPIRP. Naturally, his powers and roles, duties and powers are given in section 54F, as I mentioned, functions. But he will not interfere, right? He is not interfering. If you look at it, if you compare 54F with section 17, you'll find certain differences. 54F subsection 1 very clearly says, you see, if you look at clause number D, monitor management of affairs of the corporate. Monitor. Naturally, he has to confirm the list of creditors, maintain an updated list and all those things, but D is very important. Monitor. It is not taking over. He's just monitoring, that's all. And he's informing, he's collecting information, he's a conduit between the management and the COC. So this is exactly what it is there. He will prepare information memorandum based on the preliminary IM which is given to him. And he will also file an application for avoidance, just like in the case of CIRP also. But his powers are still there. That means he still can access the books of account. He can still access the electronic records in the information utility, and he can attend the meetings of the board of directors of the company. Though he is not running the management and affairs of the company, but he can still attend. So everything is done under his monitoring. That's all, right? So these are very important sections which you must go through it. 54F, my dear friends. I'm just skipping this because this, these slides will definitely be with you. I just want to take you to a very important sections 54K. So I just going through that. These you can read, my dear friends. Briefly, I mentioned, and in fact, in my slides, I mentioned even form numbers also for your ready reference. Right? Just go through that, and you can look at it. Powers of RP are also there. Functions are also there. Okay, friends. Before we go to relevant sections, let us understand some expressions which are used, which are little different acronyms. BRP, if I'm using the word BRP, it means base resolution plan. And remember, base resolution plan will always be submitted by CD, no one else. 2, the base resolution plan can be impaired also. Right? I think most of us are chartered accountants. We understand the meaning of the word impair. So impaired base resolution plan. So base resolution plan can be impaired, can be non-impaired. What do you mean by impaired? It is given in explanation underneath section 54F, 54K, my dear friends. So please read that carefully, but let me explain. If the base resolution plan, if the base resolution plan does not provide for full payment of the confirmed claims, supposing the list of the claimants is prepared by the CD, handed over to the RP, RP verifies that, updates it and all that, right? He updates. So supposing there are 200 creditors out there. Now, if the base resolution plan says, and their total amount is say 20 crores, assuming, and BRP says, yes, I'm going to pay 20 crores, entire 100% amount to them, then the BRP is considered unimpaired. If they say, instead of 20 crores, I'm going to pay them 19 crore 99 lakhs, 99,000 rupees, then it is considered as impaired. So even 1 rupee less than the updated claims of the creditors, it will be treated as impaired plan. There is no percentage, right? Impaired means you are not paying 100% to the creditors. If you are paying less than the full amount, then it is considered as impaired. So you can read explanation 2, section 54K. That's very important. Okay. We can have a larger discussion a little later, but let us try to understand this. Okay. Kindly confirm anybody get previous days PPT. Achha, okay, previous days. Okay. Don't worry, sir. You will get all PPTs. I will also hand over my PPT to the organizers. You will get that. Okay. So then ERP, evaluated resolution plan. Now this is another term which will come. Evaluation, because at the end of the day, the plans have to be evaluated, isn't it? The plans have to be evaluated by the COC members. Then there is another term which will be used, my dear friends, which is known as significantly better resolution plan, SBRP, significantly better resolution plan. I'll explain you these concepts when we go to 54K, but let us try to understand these are the acronyms. And last will be the approved resolution plan. So any plan which is approved by the COC later on, that will be known as approved resolution plan. So we'll start with the BRP and goes up to this. Okay. So let's try to understand what are these steps in this. Okay. Friends, my PPT naturally will be shared with you, and my PPT contains a lot of slides. In fact, I have hidden some slides because there is some repetition also. So, but the time at hand is little less. So I've skipped some of them, but you can unhide them and you can see them. So you will get the full PPT, but I'm just trying to explain it to you, right? Just listen to me, understand the process. Then if you read section 54K, now it will be easier for you. So what exactly is to be done? Who is starting the PPIRP process, friends? The PPIRP process is being started by the corporate debtor itself, isn't it? So if the corporate debtor starts, isn't it their duty to prepare a base resolution plans, which we just mentioned earlier also? So CD, the corporate debtor, has to submit the base resolution plan within 2 days of PPICD. First, they have prepared a BRP, which goes along with the notice to start the PPIRP process. Once they give the approval, you go to adjudicating authority, get it approved. Now PPRP starts and it is known as PPICD, insolvency commencement date. Now, within these 2 days, this plan will also be given to the RP, because they may change it also, because bankers may not be happy with the initial one, so preliminary, and then they may change it also. So BRP, the final BRP, what the CD is proposing, will be handed over to RP. Now, what is the duty of the RP? Naturally, under PPI, RP or CIRP, what is the main objective? The objective is to approve the plan. So RP will present this to the COC meeting. So look at this scenario. PPI, RP, the first chance, the first right to retain the company, to continue to run the company, lies with the corporate debtor. So pehla chance management ko de rahe hain, boss. They said, please give us your best resolution plan, and that is known as base resolution plan. Now, this base resolution plan will be presented to the COC. Now, COC, after reading it, they will not approve it or reject it straight away. If they are not happy, they say, oh, you are proposing this much, you are not, or you are proposing, say, to pay within 5 years. No, we want you to curtail the time or whatever. So it's a part of negotiation only. So they may tell the RP that give it to the CD or the management and tell them to revise the base resolution. Right? So they have got 2 options. Once the BRP comes, either they can approve it or they can send it back for revision. So if they approve it, my dear friends, the matter ends. The matter ends. Nothing more. This is the most shortest process. But if they are not happy and they say, please revise it, then naturally the revision is to be done. And then there could be another third situation. You remember the word impaired BRP? I told you that impairment means you are not proposing to pay 100% of the full amount. You're proposing to pay less than. So if there is an impairment, if the plan BRP contains impairment, right, then my dear friends, COC cannot approve it at the first stage. It's not that it cannot be approved later, but at the first stage, it cannot be approved. So let's try to understand. Plan which comes, if it is unimpaired, then the COC can approve it or can also ask for revision. If it is impaired, naturally, they will not approve it. Then it goes to step number 2, right? Naturally. Now, what is that step number 2? Let us try to understand. Then the COC will ask the RP now to go to the public. Well, now publish you can say expression of interest. Please invite the prospective resolution applicants. Let's have a competition now, because the management has lost its right. So if the plan is unimpaired or the plan is impaired, but not approved by the COC, then they can tell the RP to go to the public, to go to the market, to explore, you see, the market now. So if BRP is not approved, or if BRP impairs any OC claim, then RP will present plans to the committee of creditors for evaluation. That means what is going to be done? He invites plans now. Supposing 4 more plans come. Now he will place these 4 plans, not the BRP. BRP is already gone to COC. These 4 plans, new plans which have come, RP will present these plans to the committee of creditors for evaluation, not approval. They are only evaluating, right? So they'll say which one is the best out of these 4 plans received. BRP states 5th plan. It is separate. It has nothing to do with that. So then committee, on the basis of the evaluation criteria, you'll have to go to, I think, Regulation 40. Please read Regulation 40. There, the evaluation criteria and significantly best criteria, all these things are mentioned. But let's try to understand. So 4 plans come. I've got an evaluation matrix. Evaluation matrix can be anything, simple, weighted average you can give. Like Somebody is paying quicker money, somebody is paying more than 100%, somebody is paying interest also, whatever. So you can decide what are the criteria. So out of these 4 plans will be tested on the evaluation matrix. And the one which gets the highest score is known as evaluated resolution plan. This is the selection number 1, S1. So now they have to select. They're not approved yet. They have selected one plan out of the plans received on the basis of the evaluation matrix, and I will call it as ERP, Evaluated Resolution Plan. It is different than the BRP. Now, this ERP, Evaluated Resolution Plan, will be compared with BRP. Now comes the second stage of selection, my dear friends, right? Second stage of selection, there is a comparison of the evaluated resolution plan with the base resolution plan. If the ERP is significantly better than BRP, now you must be wondering, what is the criteria for treating a plan as a significantly better plan? Now that criteria will also be decided by the COC in advance. Like I'll tell you, scoring is being done on the basis of evaluation matrix. Let us take an example. 3 plans have come. Say, let us call it as plan A, plan B, plan C. Plan A gets 77 score. Plan B gets 82. Plan 3 gets, say, 78. So the plan B, which got 82, becomes now evaluated resolution plan. So it is the score of 82. Okay. Now BRP has not been scored yet. Now that will also be scored on the basis of the same evaluation matrix. Now supposing BRP, say, gets 80 marks, right? Now the COC will take a call whether ERP, Evaluated Resolution Plan, is significantly better than BRP or not. So whether 82 is better than 80 or not, significantly better. Naturally, it is better, but whether it is significantly better. So that criteria, they would always decide in advance. They must say that, look, a plan may be considered, I mean, I'm just giving an example. A plan may be considered as a significantly better if the difference in between their 2 scores is minimum 5 marks. So assuming if the BRP scored 80 and the evaluated plan had scored 85, then probably if the COC had decided like that, then difference of 5 marks would have been considered significantly better. But in this case, if it is scored 82, BRP scores 80, it is not significantly better. But let us assume there is a significantly better. So if ERP, now there is a second one situation. If the evaluated resolution plan compared with BRP turns out to be significantly better plan based on the criteria, and that criteria, my dear friends, you can read in regulation 40. Then they will select that plan. So it is known as second selection, S2, right? S2 process, selection 2. Then again, word is may. COC may select, not mandatory. COC may select. They are only selected. They're still not approved it. They will select SBRP, whatever is significantly better plan, for approval. So they say, okay, now we have selected it. Send it to the COC for approval. Now we will vote it, and if it gets a vote of 66% only, then it gets approved. So it is only a process of selection so far. So now come to the first situation. There is, in our case, ERP got 82 marks, BRP got 80 marks. COC decided minimum of 5 points difference should be there to become significantly SBRP. Supposing that difference is not there in our case. So then the ERP, Evaluated Resolution Plan, and the BRP, now both will compete together. Now there will be a competition which will start. So now the promoters will get a second chance to improve upon and compete with. This is like a Swiss challenge method will be adopted. So based on the competition, ERP or BRP will be selected. It is still not being approved, right? Supposing Evaluated resolution plan, say, has got a score of 82. ERP has got a score of 80. Promoters improve it and it gets a score of 83. ERP is improved and it gets a score of 84. And then promoters again improve it and say they get a certain score. So whosoever is the better one, based on the competition, one of the plans will be selected. So this is a third selection process now, right? And then that plan will be sent to COC for approval. And then COC may or may not approve it. If it gets an approval with 66%, then that plan is approved, and that it will be known as approved resolution plan. And if they may not approve it, well, then the whole process has failed. So that is still possible. So therefore, my dear friends, the entire learning is that promoters get a first chance to get back the company. So they have to provide a fantastic base resolution plan, and that too unimpaired. If it is impaired, then it will not be approved. So it has to go for competition. But if it is unimpaired and the COC approves it, matter ends. PPRP is over at that stage. And of course, it will go to the adjudicating authority for approval. But if it is not, then the entire process will start. RP will call for the PRA's plans. The COC will select the best resolution plan out of it, which is known as ERP. Then ERP will be compared with BRP, whether it becomes SBRP or not, significantly better plan. If it is significant, then COC may select that and send it for approval. If it is not significantly better, both of them will compete. And after the competition, whatever the best plan is there, right, it will be sent, it may be selected for approval, and then it will go for approval in a COC meeting. So a lot of complications are there. So let's understand the acronyms, my dear friends. Plan by CD is known as base resolution plan or revised. Obviously, they can revise it also. First selection process will give you ERP. The second selection process will give you SBRP, significantly better resolution plan. And third selection process will give you a plan for approval. It's not yet approved, for approval, right? And then the plan will go for approval. And if it is approved, it will be known as approved resolution plan. So I believe this is the whole system which you need to really understand this, okay? One more things which are also mentioned is that if BRP becomes ARP, supposing BRP is approved as an approved resolution plan, and now at the second stage, my dear friends, the BRP which contained impairment cannot be approved at the first stage by the COC, but in the competition, it can still be approved. So let's please understand. So it's not that BRP with impairment is not an option at all. It is an option, but it will not be accepted at the first stage. Then you'll have to face competition. But if it is, and it can be approved later on. So with impairment, approval can also be done, right? But in that case, there is one condition which is written that COC may require dilution of the shareholding, voting, or control of the promoters over CD. So if you contain impairment, then COC may say, please dilute your holding also, right? So voting or control of the promoters. And then committee of creditors can still approve the plan without dilutions to be recorded for the reasons to be recorded. So if they are happy, satisfied that no dilution is required, they can still approve it, but then you have to give reasons. And then RP will submit that approved plan to the adjudicating authority. So it can be of the promoters, BRP, it can be SBRP or ERP, whatever it is. Okay. So these are the explanations which I was mentioning. CD may submit BRP either individually or jointly with any person, so that's permitted. Claims to be considered as impaired whose resolution plan does not provide for full payment of the confirmed claims as per updated list of claims. So any single rupee less than the updated list of claims, the matter ends. Then AA has to approve within 30 days. So 90 days this process, 30 days to the AA. And then naturally, as in the case of CIRP, adjudicating authority will ensure the effective implementation. Now, friends, before I leave it to you for questions, I think this is the entire process. Rest other things you can read it on your own. But here there is an important issue. I want to give you, you see, section 54J. Now 54J talks about the jeopardy section, isn't it? I told you 54J is vesting of the management. Let us, my dear friends, go through that section. That is very, very important, right? Because it is extremely important that under what circumstances 54J order can be passed. Now, what it says, where the committee of creditors at any time during PPIRP process. So PPIRP process at any stage by a vote of not less than 66%, resolve, pass a resolution to vest the management of the CD to the RP. So they've got huge powers, right? And an application will naturally be made. And on that basis of the application, now the adjudicating authority needs to be convinced, right, of two circumstances. This is mandatory. Number one, that the affairs of the CD have been conducted in a fraudulent manner. Or there is an or in it, that there has been a gross mismanagement of the affairs of the corporate debtor. If the adjudicating authority gets convinced of any of these reasons, please remember, friends, 54J2 is very important section. Mark it. A question can come on this. Affairs of the CD are being conducted in a fraudulent manner, or there has been a gross mismanagement of the affairs of the CD, then the adjudicating authority, it is mandatory on their part to pass an order for vesting of the management of the corporate debtor. Now, friends, what are the consequences of the vesting? Now, the consequences of the vesting order, my dear friends, are written in section 54L. What does it say? It says, if you read it carefully, that if the vesting order was passed, right? Supposing if 54J order has been passed already, and if approved resolution plan does not result in change of the management or control of the CD. Because you know that the COC may require change in the management or control. And if still the control is not done, they can still approve it, but they have to give reasons. So they have given reasons, right, why there is no change in the management or control. But if these two conditions are satisfied, look at this. If vesting order was passed at any point of time, and two, if the approved resolution plan contains impairment, but there is no change in the management or control of the CD, then, my dear friends, it is mandatory on the part of the adjudicating authority to reject the plan, terminate the PPIRP, and order liquidation. So there is no point in approving a plan which contains impairment and there is no change in the control or the management and vesting order has been passed. Otherwise, it is all right. But if the vesting order has been passed, coupled with this, the second condition, then adjudicating authority can never approve the plan. So this is what it is, a serious thing which is mentioned. So just read it carefully, my dear friends. And naturally, when the PPRP will be terminated, three conditions: expiry of 90 days, plan not approved, COC decides to terminate, or you see COC has not approved the plan. So those things can be terminated, right? So termination of the PPIRP costs naturally will be treated, has to be treated as a liquidation cost because because it commences the liquidation later on, right? So these are the things which are required, my dear friends. So just look at these sections. I am not dealing with most of the things, but let us recapitulate the process once again, right? BRP or revised BRP, if it does not impair claims of the OCs, only the word is OCs here, it may be approved, may not be approved. But two, BRP or revised BRP, if it contains impairment of the claims of the OCs, then COC can ask RP to invite PRAs. Then the COC will evaluate PRAs. Then they will select the best plan, which is known as evaluated resolution plan. Now ERP will be compared with BRP, whether it is SBRP or not, significantly better plan or not. If it is, they may select for approval. If not selected, or if there is no SBRP, then ERP will compete with the BRP. So one plan, the best plan will compete with the BRP. And then you see, whatever plan is accepted, then it will be selected for approval, and then it will be sent to approval. And then the approval will take place, right? And then if it contains impairment of any claim, then COC may require dilution, or it may still approve it without dilution. But if it is coupled with the vesting order, then AA will never approve it. AA will have to reject that. So friends, this is all about PPIRP. I'm stopping my presentation here because I think it's almost time also. We can leave some portion for the question and answer sessions. I think there are few questions. Okay. The first question Mr. Shankar Rao asks is, sir, what is unimpaired? Friends, I've already explained 2 times. Please go to explanation 2, section 54K. Impairment here means not making full payment to any of the creditors, right? So if you are not making 100%, you are paying 1 rupee less to the creditors means impairment here, okay? So just read explanation 2, section 54K. I think that will be clear. Mr. Shankar Rao asks another question. If CD able to pay all claims, why is it going for PPIRP? Not able to pay, they are going for some haircut. Okay. Mr. Rao, understand in this manner. Most of the time, the promoters are willing to make payment, but what they say is they don't seek concessions, but what they seek is give us some time. So PPIRP is not only for haircuts, but it is seeking time. Like you want deferment, you want 5-year period. So naturally you can pay that because you say in 5 years I'll generate this money, I'll pay you back. So those kind of things will be there. And secondly, as I mentioned, let us not presume that if the plan is impaired, it will never be approved. No. Let us understand the consequences. If the plan is impaired, it cannot be approved by the COC at the first stage. That's one. And it says, if the plan contains impairment to the claims of the operational creditors, it is not talking about the financial creditors. It can contain impairment to the financial creditors, but it should not contain any impairment to the operational creditors to be approved at the first stage. Please understand this. Second, assuming it contains impairment to OCs also, not approved at the first stage, and the second stage, it can still, because if there is no significantly better resolution plan, then it can compete with the ERP and then it can still be approved. So it's not that it can't be approved, but you have to give your best shot when you are going for approval, isn't it? So I hope I'm clear on this. But regardless of what I'm trying to explain you, the fact of the matter is that is the reason why the PPIRP has not been successful. But anyhow, I mean, this is what it is. Sir, please suggest few case laws which covers major provision of PPIRP and have applications for LIEs as well. Sumitji, this is the best part. There are no case laws in PPIRP. Recently, I believe just last month, one only case has been approved under PPIRP because there were only 6 or 7 cases which were referred till date today to the adjudicating authority. Can you imagine it? One case, it was referred in case of a real estate. I represented some home buyers because it was a very bad plan, and ultimately that PPIRP was terminated or it was withdrawn by the promoter. So because they were primarily for the fraudulent purposes, we moved in fact application under 67A. Then they were in trouble. So therefore that was a problem. So there is only one case as of today which has been approved, and there is nothing great in that order. It is only an approval of the resolution plan. So don't go by. You don't have any case laws. You don't have to study. Remember it only theoretically and pass the exam. Don't forget about any case laws here, right? Mostly you will get theoretical questions. Okay. Mr. Pal Chabda ji saying, yes, Sandeep ji.
Yeah, if you can enter. First of all, thanks to ICI Pune chapter for organizing this. And secondly, sir, thank you so much for giving us time. And thirdly, sir, most of us will be appearing for the exam probably in 15-20 days, right? So if you can help us with some sort of exam related tips.
Well, giving you tips, you see, will take 1 hour. But anyway, I'll give you few quick tips. Okay. I think I can, Amritaji, I think we can spend 5 more minutes.
Yes, sir. Absolutely.
Okay. So number one, friends, if you ask me, read only from Bare Act, rules and regulations. You do not require any book. Please don't take any book. It will confuse you. Just keep Bare Acts, not only for IBC, but also for allied laws. Because from allied laws, there are no case laws, no case studies. So naturally, you will be able to answer the questions based on the theory part of it. Secondly, my dear friends, concentrate on the number of days, percentages, or wherever any figure is written or number is written, numerical is written. Some questions are based on that. In how many days adjudicating authority has to approve the resolution plan? 7 days, 10 days, 14 days, 21 days. The best answer is 14 days. You will have to represent it. And I can give you one standard, my dear friends. Whenever any time limit is attributable to adjudicating authority, 99% the standard is 14 days. आंख बंद करके आप 14 days select कर सकते हैं, except PPIRP, because PPIRP में थोड़ा shorten कर दिया, 7 days कर दिया. So just remember exceptions, but otherwise it is standard. If any time limit is attributed to, say, IBBI, regulator, friends, mark my words, it is standard 10 days. आंख बंद करके, right? The rest of the time periods are a little different, but anything on litigation, on litigants, it is 7 days. So remember, try to remember certain, you see this thing. And try to inculcate some formula. Like, I'll give you one more thing, right? Those who are still sticking here, I think they will be benefited with this thing. Like, one question comes, there are 11 schedules attached to IBC, 11 schedules. Now, how will you remember 11 schedules? And the examiner sometimes asks a question. Schedule number 4 relates to amendment in which law? And he gives you 4 options. Income Tax Act, Companies Act, Limited Liability Partnership Act, Customs Act. Now, if you don't remember, you can't take a guess. You cannot pick any answer. You are blank. And friends, here comes another tip. If you are blank on any question, please leave that question. Don't be greedy. This is a matter of strategy, my dear friends. And if you do some arithmetic, you see a mathematical calculation, you can safely leave 15 questions, my dear friends, and still pass the exam with 65 to 70%. Can you believe this? So do that. Don't be greedy, because if you become greedy, supposing your 15 questions go wrong, and most of the questions nowadays are 2 marks, you will earn a negative. So 15 into half mark, 7.5 marks. So even if you have scored, say, 65, minus 7.5, you will come down to 58.5. Please don't do that. So that is what my request is, because sometimes it is heartbroken. Things are there. People are scoring 59.75. People come to me and say, sir, I got 59.75. Very unfortunate. 59.5, unfortunate. So don't do that. Don't be in that category. So leave that question if you are not aware of any answer. If you're totally blank. Or in case now you can take a chance, supposing out of 4 options, A, B, C, D, you are sure A and D is not an answer, but you have a doubt between B and C, then probably you can take a chance, because then your probability of getting right becomes higher. So do that. Keep that in mind. Now, coming back to the schedules. Now, friends, there are 11 schedules. What are those schedules? When IBC came, it replaced many other laws. It changed many laws. So all those amendments are contained in the schedules only. So if you look at the schedule, they're nothing but amending various laws. But how to remember? Now, friends, very easy. Just take a piece of paper, right? Just take a piece of paper and write down in bold this thing, some formula. I'll try to give you that. So try to do that. I'm just giving you an example. You can adopt your own memorizing features. Just write down in the first sentence 32, then leave some space, 44, then leave some space, write 61. Just write like this. I think I'm showing you on your screen. 32, I mean, it may be coming in reverse because I'm showing you, but 32, 44, 61. Just write like this in first sentence. Right? In second sentence, you write 62, 93, 94. And in the third sentence, third line, write down 2, 3, 7, 8, 13. Write down like this. Just broadly, you can write 32, 44, 61, 62, 93, 94, 2, 3, 7, 8, 13. Now, what does this mean? These are nothing but your 11 schedules. Now, how to decipher this? Just write 19 before 32. Make it 1932. Write 19 before 44. It becomes 1944. And so on and so forth. 1961, 1962, 1993, 1994, then 2002, 2003, 2007, 2008, and 2013. These are your 11 schedules. Now you are coming closer to remembrance now, isn't it? Tell me which act came in 1932. Everyone is aware, Partnership Act. So your first schedule is nothing but changes in Partnership Act. Which act came in 1944? Excise Act. So just write down very small, you see, in partnership, just under that formula, partnership, excise. I'll just show you on your screen. I'm writing it like this. So 1932, underneath I've written partnership. 1944, underneath I've written excise. Then let's go to 61. I think all chartered accountants, can you forget what came in 1961? Income Tax Act. So that is 1961. अगर कोई भूल गया तो उसकी डिग्री चेक करनी पड़ेगी. 1962, well, very important, Customs Act, isn't it? 1993, SURFACE. 1994, no chartered accountant can still forget it. Finance Act of 1994, which brought in Service Tax Act, isn't it? Service Tax कौन भूल सकता? 2002 was 1993 was RDDB Act, Recovery of Debts Due to Banks and Financial Institutions. 2002 was SURFACE, right? 2003, SICA Repeal Act. SICA was repealed. 2007, well, that is slightly difficult. Just remember that, Payments and Settlement Act. 2008, no chartered accountant can forget, LLP Act. 2013, Companies Act. So friends, if you remember this formula, will you ever forget? Supposing I ask you a random question, schedule number 5 relates to amendment in which act? If I give you 5 options, you know, fifth is 32, 44, 61, 62, 62, 93. So 1993 was RDDB Act, Recovery of Debts Due to Banks and Financial Institutions. Friends, remember, I think if you start with this criteria, you are not going to forget it. So adopt your own memorization features. I think this is the one. And the last tip which I can give you, my dear friends, is read 3 times the code, the rules, and the regulations. Well, first time you can definitely read it, but second time पढ़ने में थोड़ा boring हो जाता है. I mean, you can't read an act just like that. So how to read that? Now that's a great tip which I can give you. Read along with the case laws. Why? They're like, I'll just give you one example. The first Supreme Court judgment, Innovative ICICI Bank versus Innovative Industries, right? This is the first judgment of the Supreme Court, which is in your syllabus also. Now, in that, supposing the first sentence is written by the judge, an application under Section 7 was filed by ICICI Bank against Innovative Industries. So Section 7, if it comes there, my dear friends, you will stop there, open Bayer Act, read Section 7. Whatever section is being referred in that judgment, any sentence, even if you have to read Section 7 5 times, read it. Your second reading will definitely be done like this. You will become an expert. Today, my dear friends, I don't have to open this book. You ask me to read Section 7, I'll just read it like that, because I've read it almost 1,000 times now. maybe more than that, I don't know. So just try to do that, inculcate that habit, my dear friends. And I think that will become much, much easier. So read your Bare Act second time along with the case laws. It will work both ways. You will understand the application of a section in a judgment, and you will also understand and remember the judgment vis-a-vis the section. So you will still remember, oh, innovative is relating to section 7. Second judgment, Mobilox versus Kirusa Software, section 9 judgment. Typically, you will remember, and the moment you're able to recall that, you will remember that. And for studying case laws or the cases which are there, try to remember them by way of a story. Like Mobilox versus Kirusa Software. It was a contract which was given by Star TV for a Nach Baliye program to Mobilox. And Mobilox in turn gave it to Kirusa Software. Try to remember that story. The moment Star TV comes, the moment Nach Baliye comes, the moment Mobilox comes, the whole case will come back to your memory. I think that's the way you have to create a story in your mind. If you create a story, my dear friends, remember some keywords, right? I've written one book on analysis of case laws. Unfortunately, it is not for your syllabus. I could not write it, but it is for a previous syllabus. But still, if you can get that book, it will help you. Why? Because 60% of the cases are common. So at least you can try to analyze those cases which are in syllabus that the way which I've tried to explain it. So do that, my dear friends. And I think I'm sure everyone will be absolutely passing the exam, because the time is very short. You have to pass the exam by 30th June. Otherwise, the syllabus will change. I think this is where the Pune ICI has come into your help, has brought in people like me for you. And I think you must grab that opportunity and do wonderful things. So friends, I wish you all the best and thank you for patiently hearing me. Over to you, Amrita ma'am.
Such a fantastic way to explain the nitty-gritties involved, and the best part was the exam tips and tricks to crack the syllabus. It was really amazing. I really thank you on behalf of the entire organizing team here at the Pune branch and on behalf of the participants. This session will definitely go in a long way while they are preparing for the exams and thereafter. And at the same time, the study tips and tricks are definitely useful for all of them. Also, thank you for kindly consenting to share this presentation. We will share all the presentations with the participants after the series gets over. Thank you for your valuable time and the guidance, sir. Thank you so much.
Pleasure is all mine. Thank you. And I wish all the participants very best for passing their exam. Thank you so much.
Thank you. For all the participants, we meet tomorrow morning at 8 a.m. Good day to all of you. Thank you, Ashish, sir. Thank you so much.
Thank you so much, madam. Thank you.
Thank you, Sandeep ji, and for being interactive throughout the session. And all the participants, the chat box and the Q&A tab was running throughout. Thanks a lot for the same.
Madam, just a feedback I just wanted to give on behalf of all the participants.
Yes, sir.
This was such an amazing session, and you know, this 2 hours is much less to listen to Ashish sir. This should have been at least for 4 hours. Thank you so much, madam.
Next time, definitely we will try for more such sessions for a longer duration. But wishing you all the very best, sir.
Thank you so much, madam. Thank you.